Good morning. I would ask that Mr. Hines be sworn in.
Raise your right hand.
All right.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Hines, it has come to my attention that you recorded last time's hearing on February 15th. Is that correct?
Well, I made notes. A lot of notes.
I'm asking if you made a recording.
I have no recording available for the public. I mean,
Did you record last time's hearing?
on what? Like any device or any kind of device?
That's what I'm asking.
Yes.
And you heard my ruling that day?
Well, it was pretty loud. I mean,
You heard my ruling?
about about recording is separate.
You did.
Separate from, I asked about that.
You made a motion and asked if it could be recorded, and what was my ruling on that?
Well, it was a little confusing. You were talking about Oklahoma.
I said you could not record in this courtroom.
Okay, and I asked specifically about the GoPro cam.
And I said you could not record in this courtroom.
Okay.
That was clear as a bell. There is nothing confusing about that.
Okay.
And you continued to record this hearing?
Well, do I get a hearing on? Oh, I see. I'm swearing in. Is this
I'm asking you if you recorded during that court?
is this a trial then? Is this a bench trial for...
I'm asking a question because I'm considering whether to have a contempt hearing for you right now.
A contempt hearing? Okay.
That's what I'm thinking about.
Well, I would like to prepare for this.
On my own motion, I can open up a contempt hearing.
There's no preparation?
There was no recording. I can have you put in the DC today because of this. You understand me?
Yes, sir.
Because there was an order of this court.
Okay.
This court has given you a wide latitude.
Okay.
This court has given you wide latitude.
Okay.
Has given you every benefit possible.
Okay.
Has been open to anything you need to do, but you came into this court after I made a ruling. Now, before the ruling, you could argue you had a right to record.
Okay.
After the ruling, you did not, and my question to you is, did you continue to do so?
I made as many notes as I could.
Not asking about that.
I'm going to dispute it, that there is no recording available.
You can take that up.
Okay.
And appeal my ruling, but you will not record in this courtroom.
Yes, sir.
Do you have a phone or a recording device with you right now?
No, sir, I do not. There is nothing. I have nothing recorded right now.
I'm asking if you have any device with you.
Yes, well, I have this recording, but it's off. It's been off. It can be searched. There's nothing. I brought them, but...
Do you have a cell phone with you?
No, sir.
I want you to give that to the officer, and that can be placed in the hallway. Do you have anything else?
I have nothing.
No cell phone?
This is not on. It could be. Oh,
Hand that over too.
I don't need it.
I don't trust you, that's why.
Okay.
And it's a shame, because I thought we had a relationship where I could trust you. But you came in here and violated a court order that was very clear. You asked for permission to record and I denied it. I heard your argument, Mr. Benjamin's argument, and I told you what the law is for me, that I am not allowed under the Louisiana Constitution to do this. Clear as a bell. That's all. I cannot allow recording. Do you understand that?
Yes, sir.
You have a transcript that's available to you, if you choose.
Okay, yes, sir.
So, normally, I can fine you and I can hold you in contempt for this. Do you understand that?
Yes, sir.
So, normally, I can fine you and I can hold you in contempt for this. Do you understand that?
Yes, sir.
And put you in the DC detention center for this. Do you understand that?
Yes, sir.
Okay. I'm not going to do that today because I'm fair, but I want you to be fair with this court, which means when I make a ruling, I expect you to abide by it. I've been nothing but fair with you, sir, nothing but fair. You file motions. I have them printed out for you. The clerk's office is like your paralegal. Have you brought a written motion to us yet, or do we print them out for you?
Well, I thought that was...
That's not their job. People file things. They bring them in, and they file them.
Okay.
Have we stopped you from doing that?
Yeah, I've done it in other states.
Have we stopped you from this state?
No, sir. No, sir, you have not stopped me from doing that.
Okay. So we've complied with that. We printed out things for you to file motions.
I'm using experience from other states.
Are you in other states?
No, sir.
Okay. You're in Louisiana. The clerk's office is not here to be your paralegal, but we have been very obliging to have you print out documents, have you come in and sign them and file them on your behalf. I think that's pretty decent. Don't you?
Yes, sir, I appreciate it. Yes, sir.
Okay. And then you go ahead and you go ignore my ruling and record. That's see how I feel on that. Now I'm not going to hold that against you. If I did, I'd have you locked up right now. I'm not that guy, but I am someone who expects respect in this court. Do you understand that?
Yes, sir.
And you have not shown that by flat out coming in here and recording when I told you you could not. The Supreme Court stops me from doing it. I'm telling you, you cannot. Is that clear as it can be?
It's very clear, sir.
Good. Now we can proceed with y'all's motions today. I believe you filed 3 of them. Is that right, Mr. Hines?
Yes, sir. I have the motions for... I'd like to make a statement.
Which motion is this regarding? You have 3 set today. You have an opposition to motion for discovery by the city.
Opposition to motion by the city.
That, I believe, is the first one that you have filed.
All right, okay, so the first one will be opposition to motion by the city, and then I'm prepared for motion in limine to suppress certain evidence.
That's your last one. I'm going by the order they were filed.
That's the last one, yes.
So the first one you filed was an objection to motion for discovery by the city.
Objection to motion for discovery filed by the city. I stand on the motion, and that was argued with that I have Fourth Amendment rights with prosecution. I'm asking...
In this motion, you have argued that the prosecution should be barred by asking for discovery. That is the motion I'm talking about. The objection that you said, this city of Natchitoches is time barred from asking for their discovery from you. That's the motion I'm talking about.
Yes, sir. I'd like to just stand on what was written.
Okay. Mr. Benjamin?
Your Honor, we the city objects to the substance of the motion. We know it's clear that under the rules of criminal procedure with respect to discovery, discovery is reciprocal. We filed a motion for discovery. The judge ordered that discovery be comported with and compiled with by the defendant. We complied with discovery, so we think there is nothing else to discuss of this, and we would just defer to the court for its ruling.
And, Mr. Hines, what he is saying is it's fair that if he gave you discovery, he expects it back from you. You understand what he's saying?
Yes, sir.
Now, in your motion that you filed, I'm assuming you prepared, but I'm not quite sure, but you quoted Louisiana Code of Civil Procedure Article 521 and said that in this it says, "A pretrial motion shall be made within 15 days after the arraignment." And since the arraignment hasn't happened, have a right to bring this. There is a problem with your motion, and the problem is it's out of date. That statute changed in 2020. So the argument you made here is moot. Now, the motion says pretrial motion shall be made or filed within 30 days after the receipt of initial discovery, which they have received, so the law changed. Your motion is out of date. It isn't appropriate anymore, and they have a right as soon as you filed for discovery within 30 days to ask for theirs. So not only is it fair, it's what the law is. So your motion is denied based on the fact that the law has changed, and it changed 2 years ago. You may need an updated book. So have you provided this discovery to the city?
Sir, I intend just to use only the prosecutor's discovery evidence. I have none to present to the court.
There are no last time y'all were arguing about videos. You said you were going to provide Mr. Benjamin videos and information in a Dropbox.
Yes, sir, that was before I got the packet of his discovery evidence.
In about 10 minutes, we are going to be playing our Saturday morning cartoons in the activity room, and it's going to be...
Okay.
I wasn't sure what.
So you've received nothing in your Dropbox?
No, Sir Judge, may it please the court? The city has received not one scintilla of any videos, of any recordings, of any of the things requested. We would even argue that anything that was recorded, whether it be in court or outside of court relative to this, is still discoverable by the city because discovery is wide.
It is.
And I think we understand that there have been a number of recordings. We don't have those. I know that there have been recordings, because we have seen portions of recordings on YouTube and such. Those are also discoverable. Everything he's recorded relevant to anything that he would consider to be evidence, whether he considers it evidence or not, just as he has a right to exculpatory evidence. We have the right to any even inculpatory evidence. We have the right to everything.
You understand what he's saying, Mr. Hines?
Yes, sir, I do.
In a criminal proceeding, there is open discovery, meaning that just like you had access to everything that's in their file, they have access to what you have that would have been important regarding this arrest. And so I'm not making any kind of ruling on the facts of this. As I've stated many times the last hearing as well as I will this hearing, no evidence has been put before me, none. So I'm not making any kind of finding of fact, because I am a trier of fact. So I tell you that you are required to by law to provide him what he requested. And if you have made videos in conjunction with this, if you have taken pictures in conjunction with this, if you've made statements or so, those need to be provided to the state so they have an adequate right to prepare their case. It works both ways. The door swings both ways. They provide you everything they have, and you're supposed to provide them with everything you have. So I'm ordering you to do it as I expected you to do the last time, but, again, you have a motion that requested that you were not required to. That's been denied. You are required to do so, so you need to provide any videos you've made in conjunction with this arrest, any reports, any documentation. It's in the paperwork they gave you, so whatever their request was, you have to comply.
Sir, I don't plan on presenting any evidence on my behalf. I'm using all of his. Well, it's the same audio that we have. I mean, there is nothing for me.
Well, what I'm saying is it's not as simple as just what you plan on using. He has a right just like you. He may not use everything he gave you, but he has a right, I say. He, as being the state of Louisiana, has a right to request this documentation. And, again, I say, video. I don't even know what's out there. All I'm saying is that he and you have made use the word video, so I'm saying video. If it's pictures, some still pictures, that's what's required. But whatever is in his motion, and he is required by law to receive from you if you've made something that surrounds the circumstances of this incident. Just like if you had a friend watching it, and you didn't give him a name. You'd say, I have to give you that name of that individual, because they are a witness. If there is no one in the presence, then there are no witnesses. So sometimes there are witnesses, sometimes there's video, sometimes there's still pictures. So anything like that concerning this incident, he has a right to request it, and I believe he's requested it, and you have to turn it over.
I'm not familiar with the law that requires me to just provide blankets of evidence for discovery on my behalf.
It's not blanket evidence. It's what's in his required motion. It's what he's asking for, things that surround this incident, you are required to produce.
Okay, so I don't plan on presenting it, but I should still hand over some videos to Mr. Benjamin in regard to the incident. This arrest that occurred on January 22nd.
Here's the thing. He is required to give you exculpatory evidence, which means evidence that would otherwise prove that you're innocent. What if he wasn't going to use it? Should he just hold on to it and not tell you about it?
I believe, sir.
You're required to have it, right, because you requested it.
Yes, sir, as part of my defense.
Right.
I'm the defendant, and prosecution has a higher burden. They have the burden to prove.
They do.
Okay, beyond a reasonable doubt.
Right.
And I am in the position of defending myself.
Correct.
And I invoke my Fourth Amendment rights.
And I expect that when you come to trial, you don't have to say a word. You don't have to say a word. You don't have to say a bit of evidence. You don't have to do anything at trial, but he has a right to any kind of information that you may have through discovery.
Yes, sir, so that it would not be considered a Fourth Amendment issue to demand me to provide evidence to Mr. Benjamin? Is that the point to take?
Correct, that's correct. That's not a violation of the Fourth Amendment.
Okay.
Okay. So you understand, so I'm ordering you to comply with discovery. I thought we resolved that last time. Please provide any discovery to Mr. Benjamin as he's requested it. He filed a formal motion. You have a motion from him that says what he is requiring. From that motion, you can, just like the one you sent to him, or you send him a motion saying I want these things. That's what he's provided to you. You need to respond to those. Now if there's specific items that you feel you shouldn't have responded, then you can raise those and say these items I didn't think were necessary. You can do that, but again I'm not going to legally advise you how to defend yourself, I am saying, but you do need to comply with the order that's been given. You can't blanket say I'm not giving him anything.
Yes, sir. It just wasn't clear during the last hearing on February 15th. It sounded like if I was presenting information, that should be what I provide to Mr. Benjamin, but now?
Well, it's in response to his motion. That's why I didn't write his motion, he did. The state of Louisiana, the city of Natchitoches, has given you a motion saying we want these things. You have to respond to those things as opposed to you just saying no. If there is a specific particular incident, you want to say no, this item can't go because of this, that and the other, you can do that, but you do have to respond to his request. And you haven't done that. You said that he shouldn't be able to get it at all, which again, was this motion, which was relying on out-of-date law. But again, you do need to provide him, and, if not, address each specific one and say this is why not this.
Yes, sir. I understand even if it's a no, I still have to make a response.
It shouldn't be a blanket no. I mean, unless you're going to give him absolutely nothing that exists. Are you going to say he gets none of your discovery, he gets none of your information?
I was just under the impression if I was going to use something, then present it, but everything, it sounds like that. I'm not sure.
Okay. Well, did you hear my ruling?
Yes, sir, I did.
Okay. You did receive it though, right?
Yes, sir.
I have it clocked in, and it says copy provided by defendant this date. This was February 24th is when I have it clocked in, but you received it?
February 24th?
You received what he's saying in his motion, his response to your motion?
The opposition to...
Yes.
Answer to City of Natchitoches motion to quash defendant's motion to quash as it relates to improper admission of facts not in evidence and request for consideration.
I'm seeing which one you have. The one I'm referring to says, City of Natchitoches motion to quash defendant's motion to dismiss.
Motion to dismiss. Okay, oh yeah, that was earlier. Yes, sir.
So you've gotten that?
Yes, sir.
Does that change your argument in any sort of way?
No, sir.
Because what he is doing is he's responding saying why he doesn't think you should be able to really, in essence, this is a reconsideration. What you've asked for is another request to quash their attempt to bring you to court. My response is similar to the first time. Again, this is an ID request, and there is some language in here that I don't have jurisdiction over you. I dispute that based on the fact that there was an arrest and the arrest occurred within the city of Natchitoches within Ward 1, state of Louisiana, so I do have jurisdiction over this matter. Further, I'm not saying that I'm going to deny your motion. As I said last time, I'm not denying your motion. I just feel that it is difficult for me to try to make a ruling on what you're saying based on what you're verbally saying or in your motion and what Mr. Benjamin is saying. There is no evidence before this court, and as such there are two options. Either we have a hearing, which is in essence a trial, and then have a trial again, or you just have the trial. My position is we have the trial, because you would be having to testify at your first hearing to present your side of the case, or they would. And so especially if you're planning on not testifying and not presenting any evidence, then I'm going to wait for the trial to make a ruling on this. Now, after the trial, if you find this was an unauthorized arrest, and that you were improperly arrested, then I can dismiss it, and I can quash it then. But I'm not going to do it in advance with no evidence just because your motion says one position, and Mr. Benjamin says another. There is no evidence in front of me, and evidence is taken by testimony, by documents that are submitted to the court, and verified by a witness. That's evidence. Evidence is not what you're saying and what he's saying. So if I'm going to make a ruling, I'm not going to do it on paper. I'm going to do it from hearing facts and figures, whether it's from you or as witnesses, whoever it is. This is an evidence, and as such, I'm not going to dismiss your suit or your case. The case against you will continue. Again, you have a right at a trial to have everything come out, but I just think this is premature. So I'm not dismissing it. I'm just denying it at this time, but it can be raised again at the trial. So your last motion is a motion in limine to suppress evidence.
Yes, sir. In my case history, I have an arrest warrant, and that I believe that is evidence or testimony presented for the courts. And
I have not reviewed. I reviewed an arrest warrant initially to assign the arrest warrant, but that's not evidence, because it hasn't been brought to court. That is enough to be able to say someone needs to be arrested. It is not enough to convict somebody, and so this is a court where you have evidence, and you make rulings whether to convict or not to convict. If Mr. Benjamin does not provide enough evidence that you are guilty beyond a reasonable doubt, then you will not be found guilty. That's what evidence, and that's what this court is for. It's literally a scale to weigh what is provided to me. At this point, again, I do not have evidence. Now you have asked for certain evidence to be suppressed. None of that evidence has been put forward yet. So, again, this is a little premature. It would be your welcome to request any kind of testimony like this to me on the day of trial. You can say, Your Honor, refer to the motion in limine, we ask this to be suppressed, and at that time I can make a ruling if it is. But right now, there is no evidence in front of me. There is nothing about whatever was on your computer, what have you. That's not before the court. No one has said anything in this chair as a witness, under oath, about anything, and so you're a little ahead of yourself saying that it needs to be suppressed. It hadn't been brought as evidence.
yes, sir, I would resubmit the motion in limine to suppress certain evidence after arraignment.
And you're allowed to do that. Well, I would say not after arraignment, but necessarily if that evidence is attempted to be produced. Again, there is a reason that the scale of justice is blindfolded, because you're blind to anything that comes before you until it comes into evidence in this seat. Everything else is just talking. Nothing that you and Mr. Benjamin have said today is evidence. It's just your positions and arguments, but you will have an opportunity to have a trial at which he must provide enough evidence to find you guilty. If he does not, then you will not be guilty. So, you'll have a trial, and that's the time when you can say this evidence should not be brought, it was not, for whatever reason. I'm not going to tell you how to argue your case. But for whatever reason, this evidence should not be brought, and it should be suppressed, but again, that's a trial issue, and that's what I would suggest you bring it up as. But, again, I'm not going to sit here and lawyer your case up, but I'm going to deny it at this time, but I'm not going to dismiss it. Again, you have a right to bring both your last two motions, which is the motion to quash and the motion in limine at the time of trial. So I believe that is your three motions that you had today, am I right? Does that sound right, the three you filed?
Yes, sir. I would like to clear up just the affidavit for arrest warrant is in a particular category of not in the court. It's entirely just only for an arrest, to effect an arrest.
Correct.
That's not in the court?
Correct. I have not heard any evidence in this court. As far as that was for your arrest. For a conviction, it's a totally different story. People get arrested all the time, and they're never convicted. But this is the time at which you will be having evidence. When we set this matter for trial, we'll have evidence, people will be sworn in, officers, laymen, whoever, and, again, you have the right to try your case and have evidence put forward and not. That's totally up to you. If you want to testify or not, that's up to you. That is your Fifth Amendment right not to incriminate yourself. I'm trying to prevent you also from incriminating yourself at an initial hearing, because if you were to testify or argue on your behalf at that point, you would be, in essence, waiving your right to Fifth Amendment. So I'm trying to prevent you from doing that, which you may appreciate or not, because I think that you have already said you don't want to present anything. And you may not be testifying at that time. That's up to you. I'm certainly not asking you to do that. You have a right under the Fifth Amendment of the Constitution not to testify. It's Mr. Benjamin's job to prove you guilty. You don't have to do anything, but anyway, that's up to you. Mr. Benjamin, do you have any motions yourself today?
Your Honor, the state has no motions.
Okay. Then the last thing we have for today is arraignment. So as you may know, an arraignment is simply a process which you plead guilty or not guilty, and then that moves the matter to a trial. So are you ready to enter a plea today, sir?
Yes, sir.
And what is your plea today?
Not guilty.
Absolutely. So I'm going to accept your plea of not guilty, and we're going to set this matter for trial. Again, since this matter has had a lot of motions, and we know for sure it will go for trial, let's set this for a date that is available for everybody, and it won't be your usual criminal date. It will be an actual trial date much like today. Are there any suggestions by Mr. Benjamin, your office, or our calendar? We'll start with Mr. Benjamin. Do you have any dates that you're not available or you cannot make? Okay. I mean, we can have it, and again, let me stress, there is not a rush to have the trial. We're going to be here every day anyway. So it's not a rush, but I'm just saying if you want, we can have this as soon as the 28th, which is a Monday. That's only 2 weeks, oh that's 3 weeks, but that's up to you. I don't know how soon you want it or how long you want to take.
Yes, sir. I would also like to resubmit my motion in limine to suppress certain evidence now that we have gone through the arraignment.
Certainly. And again, I'm going to go ahead and I'm not going to dismiss it, but I'm going to deny it until the actual trial. Which means at trial date, you can raise that.
Your Honor, I wanted to ask, is March 17th available?
No. March 17th is not available. And that's just the court's calendar. I can't make it that day.
March 23rd?
I'm available if you are. If you need more time, let me know. I'm just setting a date, because we're picking dates. It could be a month from now. It doesn't matter to me. I just want you to both be able to be accommodated by this calendar, so you tell me.
March 23 RD.
Is a Wednesday.
Would be okay with the state. March 28th is actually the beginning of jury term, and I'll be in jury trial.
Well, March 23rd. That would be approximately 2 weeks and 2 days from now. Is that a good time for you, Mr. Hines, or not?
Yes, sir.
Okay. Then we'll set it for March 23rd.
And at what time, Judge?
9 o'clock. So I don't think we have anything set yet. All right, having taken that, we'll set this trial for March 23rd, and any other motions y'all plan on filing should be done ahead of that, considerably ahead of that if there is some argument. Otherwise, I'll see y'all back here on the 23rd at 9 o'clock.
Thank you.
All right. Thank y'all.